So how does a Chapter 13 bankruptcy work exactly? Watch our next video and find out. So a Chapter 13 bankruptcy is simply a debt consolidation and repayment plan under the protection of the federal courts. Now, there are some restrictions in regards to who can file a Chapter 13 bankruptcy. Only individuals can file. If you're a company and you're needing to restructure, then you're looking at a Chapter 11. There are also some debt limits on a Chapter 13. And if you go to our site, we have those because it actually changes. But if you have too much in terms of your debt, both secured and unsecured, you may get moved to a Chapter 11. Now, most folks that we meet with don't have to worry about this. The secured debt limit is like 1.1 million or whatnot, and the unsecured is like 300-something thousand. So most of our clients don't have this problem. And again, if you go to our site, we actually have the most recent numbers, so you can just check and make sure if you are over that number. And if that's the case, you would look at a Chapter 11. But for most people, that's not the case. But in terms of how a Chapter 13 works, it's pretty easy. Folks come to us because maybe they've gotten behind on their mortgage, their car got repossessed, they have child support arrears, and they're getting ready to lose their license or even worse, get out of jail. So what we can do with the Chapter 13 is simply take whatever, for example, on a mortgage, we take whatever they got behind on their mortgage, we put it into a pot, so to speak. That's how I always explain it to my clients, with all your other bills, and then we can do a workout plan that can go up to 5 years. Now, the great thing about Chapter 13, and this is completely dependent on each individual's case, but for a lot of my clients, they can restructure their debt. They can cram down their cars to just the value of the car. So if you're upside down on a vehicle, that can be great. That can save you like $10,000 easily. But not only that, they may not have to pay back any of their unsecured debt either. So if they've got credit cards, medical bills, collections, old repossessions, even old tax debt, they won't have to repay any of that through their bankruptcy. So the only thing they're really repaying is going to be that secured and priority debt. So for a lot of folks, Chapter 13 just gives them some breathing room, but it allows them to keep their assets. So, with a Chapter 7, you may be looking at surrendering assets or having a trustee sell your assets. That's a totally different process. But with a 13, I tell clients, you can file a Chapter 13, you can keep everything you want to. You may have to pay for everything. You may not be able to get rid of all your unsecured debt if you're trying to keep 2 pieces of property, but hey, at the end of the day, it's your ball game. And if you have the money to be able to pay that restructure plan, great, do it. Because sometimes people have just gotten behind because maybe they lost their job, but now they're making great money, but they're looking at a foreclosure and they can't catch up. So there's a lot of different reasons why someone needs to look at filing a 13, and they want to keep everything. And they're like, hey, I can pay this. I just need a little breathing room. So a Chapter 13 bankruptcy is, again, a debt consolidation repayment plan under the protection of the federal courts. And the process is actually really simple. We file the case. In about 30 to 45 days, you go to court. I always tell my clients it's not like Law and Order on television. Bankruptcy court, you're not in a courtroom, you're not in front of a judge. We're in a conference room and we're sitting right beside our clients. So anyway, it's not anything to get stressed out about. But we go to the hearing, and at the hearing, the trustee will review the petition. They'll ask you a few questions, and if you go to our website, we actually have a list of questions that trustees will usually ask folks. But they will ask you some questions, and then at the end of the hearing, the trustee will say that they have objections. And it's nothing to freak out about because the trustees always have objections. It is very weird to see a case where a trustee doesn't have an objection. And all the trustee is saying is, hey, these are the items that we need for you in order to get your case approved. So it's things like, I need to see proof that you've been making your mortgage payment. We need to see proof of recent pay stubs. I need to see proof that you filed your taxes. These are all really, really usually basic things, but they will tell us what's needed. So the next step is we've got another 30 days usually before your second hearing, which is called the confirmation hearing. And it's at that hearing where the trustee is going to check to see, have you been making all your payments to the court? Have you provided the documents the trustee told you that they needed? So, hopefully you've gotten everything together by that court date. And my office is going to be stalking you via email. We're going to send you text messages that, we need to get all this information. So hopefully you've gotten everything to us. But let's say, because this happens, let's say the trustee needs to see taxes, and the IRS filed a crazy claim in your case and said, hey, you didn't file taxes for these years, this year, and you're like, I know I did. But by the time the hearing comes up, you've not found copies of those returns, or maybe you do have to file those returns. Well, the good news is we can ask the court to give you a reset. So we can say, look, the client's done all of this. They've paid their money. It's just there are just a couple of things that they still need a little time on. Most trustees have no problem granting you some additional time. Now, keep in mind, you need to have already taken care of most of your other things. So the number one reason cases get dismissed in bankruptcy is real simple: money. When you file a bankruptcy, a Chapter 13, you are agreeing to start making a monthly payment to the bankruptcy court, okay? It's in our attorney-client agreement. It's all over everything you get from the court. When you go to court, the trustee reminds you. So the trustee doesn't want to hear, oh, it didn't start coming out of my paycheck until this date. Doesn't matter. You should have been watching your paycheck because you knew you had this amount that was due. So nobody wants to hear those excuses because you know better. So you need to really make sure, number one, when you file your case, if it is supposed to be coming out of your paycheck, which for most cases it is, if you see that that's not coming out, because it's your payroll. So I don't have any control of your payroll. And even though the court sends out an order, they don't either. So it's up to you to make sure that you are checking your paycheck to make sure that money come out. And if it didn't, guess what? You can go straight to the trustee's site and you can make that payment yourself. So there is no excuse for your trustee payment not being late, and saying that it just didn't come out of your check isn't going to cut it. And the judges don't want to hear it, and the trustees don't want to hear it, because everybody reminds you at the hearing. So our job is to hammer this into your head so that you're prepared, because that's what we do. We're supposed to be getting you prepared for your confirmation case. So we can ask for a reset for a hearing, but you better make sure you've got everything else taken care of. If it's only one or two items you're missing, the trustees are usually fine to do a reset. So just make sure, big thing with Chapter 13 cases is that you're communicating with your attorney and you're making your payments. Because a Chapter 13 is a debt consolidation repayment plan. Sometimes I'll have clients say, well, I can't afford that. I get it. If you can't afford it, you need to let some assets go and do a Chapter 7. So sometimes you have to have, as I say, a come to Jesus moment and say, I can't afford this. And your car might be really nice and you love your car, but guess what? It might need to go because you can't afford it. So Chapter 13, again, is a debt consolidation repayment plan, but it's a repayment plan, so keep that in mind. The other thing you need to remember is once your case gets approved, we call it confirmed. Once your case gets approved, it's a really, really straightforward process in that from that point going forward, the only thing you're going to be doing is, of course, you continue to make your payments every month, but every year you file your taxes and you need to provide a copy of your taxes, not only to the trustee, but you need to provide a copy to my office. So please don't forget that. And we will send reminders. We will send emails. We will send text messages to say, hey, it's tax return time. Don't forget, you need to send these into our office, because your case will get dismissed if you are not submitting this. And it may be that you can keep your entire tax refund. That's not what it's about. Even if you can keep your entire tax refund, you might be in a 100% plan or you might be with a trustee that doesn't require it, you still have to provide your tax return. So keep that in mind, because remember, your case is approved in order to show what your income is, and that's what your payment is based on. But if all of a sudden you're making twice as much money, well, guess what? You could be paying back your creditors faster or even more if you're not repaying certain creditors. So that's what the trustee is checking for, and you have to provide a copy of your tax return every year you're in bankruptcy. And of course, once your Chapter 13 case gets approved, if anything comes up, because things can come up, you could lose your job, you could get sick, your car could be in an accident, you need to get a new car. There's lots of things that can come up. The nice thing about Chapter 13 is there's ways to address all that. So I tell clients, if something comes up, all you need to do is just reach out. Send me an email, call the office, set up a time to come in and meet with one of us, and we are more than happy to tell you, here are the options to keep your case going. And sometimes it might be a better option to let the case dismiss and refile, which you usually are more than able to do. So, before you have a panic attack, make sure that you contact us so we can go through the things that you may be able to do in Chapter 13, because Chapter 13, believe it or not, is pretty flexible. And the other thing is, sometimes something happens and a client says, you know what, I'm just gonna let this go. I'm gonna let the house go back and let the car go back, or maybe they got a loan modification and they don't need to worry about mortgage arrears. It may be time to convert to a 7. So you can do that. You can simply, we can file a motion and we can convert the case to Chapter 7 as long as you qualify. But again, you need to make sure you meet with us, because there's certain items we need to review before we do that. So that's an overview of Chapter 13. I don't have enough time to go over every single facet. However, if you look on our channel, we have lots of little videos, smaller videos that kind of address specific topics like motions to suspend, motions to incur, tax refunds, applications to employ, all kinds of different things. So I always invite clients to, when you have time, check out our channel, go through, the different things that could come up. And then that way, if they do, in your case, you always know, how we can assist. If you have questions about Chapter 13 or just bankruptcy in general, please don't hesitate to contact us. Our information is below, and we're always happy to assist.